Welcome to part 2 of Rule 14 on summons under the 2019 amendments to the Rules of Civil Procedure. Section 11. Service upon spouses. When spouses are sued jointly, service of summons should be made to each spouse individually. Section 12. Service upon domestic private juridical entity. When the defendant is a corporation, partnership, or association organized under the laws of the Philippines with a juridical personality, service may be made on the president, managing partner, general manager, corporate secretary, treasurer, or in-house counsel of the corporation wherever they may be found, or in their absence or unavailability on their secretaries. If such service cannot be made upon any of the foregoing persons, it shall be made upon the person who customarily receives the correspondence for the defendant at its principal office. In case the domestic juridical entity is under receivership or liquidation, service of summons shall be made on the receiver or liquidator as the case may be. Should there be a refusal on the part of the persons above mentioned to receive summons, despite at least 3 attempts on 2 different dates, service may be made electronically if allowed by the court, as provided under Section 6 of this rule. Please take note of the following enumeration under Section 12. Please take note that under the amendments, substituted service may be effected even when the defendant is a private corporation. Substituted service may be done so electronically if allowed by the court. Substituted service may be resorted to in accordance with Section 6, Rule 14. Section 6. Substituted service. If, for justifiable causes, the defendant cannot be served personally after at least 3 attempts on 2 different dates. D. By sending an electronic mail to the defendant's electronic mail address if allowed by the court. Section 13. Duty of counsel of record. Where the summons is improperly served and a lawyer makes a special appearance on behalf of the defendant to, among others, question the validity of service of summons, the counsel shall be deputized by the court to serve summons on his or her client. Section 14. Service upon foreign private juridical entities. When the defendant is a foreign private juridical entity which has transacted or is doing business in the Philippines as defined by law, service may be made on its resident agent designated in accordance with law for that purpose, or, if there is no such agent, on the government official designated by law to that effect, or on any of its officers, agents, directors, or trustees within the Philippines. If the foreign private juridical entity is not registered in the Philippines or has no resident agent, but has transacted or is doing business in it as defined by law, such service may, with leave of court, be effected outside of the Philippines through any of the following means: A. By personal service coursed through the appropriate court in a foreign country with the assistance of the Department of Foreign Affairs. B. By publication once in a newspaper of general circulation in the country where the defendant may be found, and by serving a copy of the summons and the court order by registered mail at the last known address of the defendant. C. By facsimile. D. By electronic means with the prescribed proof of service. Or E. By such other means as the court in its discretion may direct. Section 15. Service upon public corporations. When the defendant is the Republic of the Philippines, service may be effected on the Solicitor General. In case of a province, city, or municipality or like public corporations, service may be effected on its executive head or on such other officer or officers as the law or the court may direct. Section 16. Service upon defendant whose identity or whereabouts are unknown. In any action where the defendant is designated as an unknown owner or the like, or whenever his or her whereabouts are unknown and cannot be ascertained by diligent inquiry within 90 calendar days from the commencement of the action, service may, by leave of court, be effected upon him or her by publication in a newspaper of general circulation, and in such places and for such time as the court may order. Any order granting such leave shall specify a reasonable time which shall not be less than 60 calendar days after notice within which the defendant must answer. Section 17. Extraterritorial service. When the defendant does not reside and is not found in the Philippines, and the action affects the personal status of the plaintiff or relates to, or the subject of which is property within the Philippines in which the defendant has or claims a lien or interest, actual or contingent, or in which the relief demanded consists wholly or in part in excluding the defendant from any interest therein, or the property of the defendant has been attached in the Philippines. Service may, by leave of court, be effected out of the Philippines by personal service as under Section 6, or as provided for in international conventions to which Philippines is a party, or by publication in a newspaper of general circulation in such places and for such time as the court may order, in which case a copy of the summons and order of the court shall be sent by registered mail to the last known address of the defendant, or in any other manner the court may deem sufficient. Any order granting such leave shall specify a reasonable time which shall not be less than 60 calendar days after notice, within which the defendant must answer. As pronounced in Section 17, extraterritorial service of summons may be effected in the following manner: by leave of court. A. Personal or substituted service under Section 6. B. As provided for in international conventions to which the Philippines is a party. Or C. By publication in a newspaper of general circulation. Meanwhile, the rule likewise provides that a copy of the summons shall be sent by registered mail to the last known address of the defendant, or in any other manner the court may deem sufficient. Section 18. Residence temporarily out of the Philippines. When any action is commenced against a defendant who ordinarily resides within the Philippines but who is temporarily out of its service may, by leave of court, be also effected out of the Philippines as under the preceding section. Section 19. Leave of court. Any application to the court under this rule for leave to effect service in any manner for which leave of court is necessary shall be made by motion in writing, supported by affidavit of the plaintiff or some person on his behalf, setting forth the grounds for the application. Section 20. Return. Within 30 calendar days from the issuance of summons by the clerk of court and receipt thereof, the sheriff or process server or person authorized by the court shall complete its service. Within 5 calendar days from service of summons, the server shall file with the court and serve a copy of the return to the plaintiff's counsel personally by registered mail or by electronic means authorized by the rules. Should substituted service have been effected, the return shall state the following: 1. The impossibility of prompt personal service within a period of 30 calendar days from issue and receipt of summons. 2. The date and time of the 3 attempts on at least 2 different dates to cause personal service and the details of the inquiries made to locate the defendant residing thereat. And 3. The name of the person at least 18 years of age and of sufficient discretion residing thereat, name of competent person in charge of the defendant's office or regular place of business, or name of the officer of the homeowners association or condominium corporation or its chief security officer in charge of the community or building where the defendant may be found. Section 21. Proof of service. The proof of service of a summons shall be made in writing by the server and shall set forth the manner, place, and date of service, shall specify any papers which have been served with the process and the name of the person who received the same, and shall be sworn to when made by a person other than a sheriff or his or her deputy. If summons was served by electronic mail, a printout of said email with a copy of the summons as served and the affidavit of the person mailing shall constitute as proof of service. Section 22. Proof of service by publication. If the service has been made by publication, service may be proved by the affidavit of the publisher, editor, business, or advertising manager, to which affidavit a copy of the publication shall be attached, and by an affidavit showing the deposit of a copy of the summons and order for publication in the post office, postage prepaid, directed to the defendant by registered mail to his or her last known address. Section 23. Voluntary appearance. The defendant's voluntary appearance in the action shall be equivalent to service of summons. The inclusion in a motion to dismiss of other grounds aside from lack of jurisdiction over the person of the defendant shall be deemed a voluntary appearance. Now that concludes Rule 14 on summons under the 2019 amendments to the Rules of Civil Procedure. Thank you for watching.